Welcome to the IPCS Career Panel today. I'm Cameron Stoll. I'll be your moderator. I'm the Vice President of the Society. I wanted to thank all of our speakers for coming and talking to us today. And I would also like to thank Jen, our President, and the board for their hard work putting all this together. And I would like to thank you guys for coming and eating our food and whatnot. I would also like to remind all of you about our symposium, which is on February 23rd. It's our Hot Topics and IP Law Symposium. We do it annually. It's sort of our big event. And we'll have two main panels. One is the 2006-2007 patent law decisions. So it's sort of the new hot topics in patent law. And our second is video and movie file sharing. So that's certainly going to be an interesting one about copyright. So hopefully all of you will attend. And I will ask a question to the panelists and let each of them respond, and then move on to the next question. And when I'm finished, I will allow for approximately a 10-minute question and answer session so that you guys can ask more detailed questions to each of our speakers. I would like to introduce our panelists today. We have Bill Wofford from the Hutchinson Law Group. He's brought M&Ms. And
You're going to have to come down to the front to get them.
At the end, come get M&Ms. They're very colorful. His practice focuses on corporate and transactional matters for life sciences and technology companies. His clients are innovators in the areas of cell therapy, drug discovery, development and delivery, healthcare services, and related fields. He assists growing and established companies raise capital, acquire and out-license technology, collaborate with strategic partners, and engage in mergers and acquisitions. A graduate of UVA, BA in 1989 and his JD in 1994, he began his legal career with White & Case in New York City. Mr. Wofford then moved to RTP in 1997, where he practiced with Womble Carlyle prior to joining Hutchinson Law Group in 2001. Mr. Wofford is active in numerous businesses and charitable organizations, including the Council for Entrepreneurial Development, the Carborough Parks Project, the North Carolina Bioscience Industry Organization, the American Lung Association of North Carolina, the Licensing Executive Society, SEBIO, the ABA's Business Section and Science and Technology Committee, and the Camden Institute. His work with CED and SEBIO has focused on identifying promising startup companies and coaching them on business formation, strategy, and raising capital. Mr. Wofford also helps research universities collaborating with businesses in the commercialization of technology. Mr. Stephen Moore is from Kilpatrick Stockton. He's a partner in the litigation department and a member of the firm's patent litigation team, where he focuses on representing numerous clients in patent infringement litigation in various industries. Mr. Moore also has substantial experience in other areas of commercial litigation, including class actions, consumer credit, labor and employment, general contract, and Fred and RICO disputes. Mr. Moore is a graduate of Duke University. He's actually a double Dukey, graduating with a degree in economics in 1993 and his JD from Duke Law in 1996. He served as a law clerk to the Honorable Richard C. Freeman, Senior U.S. District Judge in Atlanta, Georgia, and to the Honorable Alexander Denson, U.S. Magistrate Judge in Raleigh, North Carolina. Mr. Ken Sibley is from Myers-Beagle. He has been practicing intellectual property law since 1985 and focuses his practice in biotechnology and chemical areas. Mr. Sibley has received his BA magna cum laude in biology and psychology from Lycoming College, his Master of Arts in neurobiology from the University of Rochester, and his JD from Duke University. He's a member of the North Carolina Bar and is registered to practice before the U.S. Patent and Trademark Office. He has been a senior lecturing fellow here at Duke Law since 1996, where he teaches courses on advanced patent law and patent claim drafting. He is an author and editor of The Law and Strategy of Biotechnology Patents and has authored numerous articles relating to patent law. He is an associate member of the Association of University Technology Managers and the American Intellectual Property Law Association. He is on the board of directors of the Triangle Intellectual Property Law Association. In 2004, he was ranked the number one patent and IP lawyer in North Carolina by Business North Carolina Magazine, based on a poll of North Carolina lawyers. Tim Meggs is to his left. He's in-house counsel for BD Technologies, and you might have to excuse me because this is a handwritten information sheet, so if I butcher it, I really apologize. He got his BS in biology from East Carolina University in 1989, his JD from UNC Chapel Hill in 1993, and his master's from Johns Hopkins University in biotechnology in 2006. He was in private practice in Raleigh and Greensboro. From 1996 to 2002, he was in-house with CIBA. You might have to help me with Gurgi. Is it Gurgi, Novartis, and Syngenta?
Ciba-Geigy, Novartis, and Syngenta.
It was close.
It was all the same company.
Sort of close. In their agricultural biotechnology research unit in 2002 to 2003, he was in-house counsel with Novartis and RTP in the gene therapy division. And 2004 to 2005, he was of counsel with, you might have to help.
Shagru
Maya in DC. And since March of '05, he was with BD Technologies at their corporate research center in Research Triangle Park, North Carolina. And lastly, we have Mitch Tuchman from Womble Carlisle. Copyright law is central to Mitch's practice. He has assisted clients with matters concerning the registration, licensing, and enforcement of copyrights in subject matters as diverse as architecture, audio recording devices, books, computer software, distance learning courses, fabric and furniture designs, internet screen displays, maps, motion pictures, murals, music composition, recording and performance, photography, and picture postcards. As part of his practice, Mr. Tuchman prepares publishing and other copyright licensing agreements. He was a publisher himself for 14 years prior to becoming an attorney and advises clients with respect to rights of privacy and publicity. He also assists clients in trademark registration and enforcement and the preparation of complex trademark, trade secret, and patent licensing agreements. He contributes frequently to legal and scholarly journals. So now I will begin with the first question. Please describe what area of IP law you practice and what your job encompasses.
Just going down the line?
Sure.
So I do a great deal of licensing and collaboration work, primarily in the life sciences. So my typical client would be either a biotechnology company that had started based on university patents that would have then been licensed to the startup company. I'd work with them on that kind of, on the initial phase, the acquiring the technology. And then sooner or later for a new product to get to the market, it's probably going to involve working with a larger pharmaceutical company. And so down the line, there will be out-licensing transactions. So those kinds of deals I do a lot of with biotech companies. And then in the specialty pharmaceuticals or medical device arena, similar story, but generally there's less involvement of university technology and more direct interaction with other businesses. So in short, primarily licensing transactions in the life sciences.
Mr. Moore?
I'm a litigator, and my practice the last 5 years or so has been 80 to 90% of patent litigation, which, as many of you know, is quite a growing and active field. I did not come to it through the traditional IP route. I was actually a general commercial litigator for several years before specializing in patent litigation. I have no particular restriction on the type of technology. I've worked with technology ranging from medical devices and products to textiles to internet and software-related disputes to even litigating a patent case over the wrapping used for chalupas at Taco Bell on behalf of a client last year. And am involved in litigation on behalf of both patent owners as well as companies accused of infringing patents and from the beginning pre-suit investigation stage all the way through jury trials in patent cases.
I'm Ken Sibley. I have an office-based practice in what we call patent preparation and prosecution. So I meet with scientists and business development people and write patent applications, file them in the U.S. Patent Office, and eventually, when the U.S. Patent Office gets around to responding to us, then negotiate with the U.S. Patent Office. I'll work in conjunction with foreign patent attorneys in filing and prosecuting corresponding applications in other countries. And then I'll work back in conjunction with clients in keeping track of the next generation of technology and how it all relates to the technology that we've previously filed on. So that is sometimes called portfolio management.
So Tim Meggs, I have a pretty typical in-house patent job, have most of my career. BD has a corporate research center in RTP, and there's about, I don't know, 175 or so researchers there, and I'm in charge of managing the intellectual property for the site. So I guess there's three main aspects of what I do. One is overseeing the patent process. When the inventors come up with inventions, I meet with them. The first screen is through me, and then if we decide to file a patent application on an invention, we'll engage outside counsel to draft it and prosecute it. And also foreign counsel do the same thing overseas. The second main thing I'm involved with is licensing and other type of transactional work, drafting collaborative research agreements with various other parties that our researchers want to collaborate with. They never can keep everything in-house. It's a lot of times involves collaborating with university researchers or other companies. Sometimes it's cross-licensing. Sometimes it's just developing something from scratch. And generating IP, so doing the agreements that are necessary for that. And the third thing is a little harder to define, but it's just the overall counseling role of being in-house. In-house patent lawyers are brought into, and we spend half our days in meetings. A lot of times we feel as much like research managers as we do lawyers. We're in meetings with researchers and business development types all day and going to lab meetings even, just help and advise on kind of a day-to-day basis, whatever legal issues can come up.
I work principally with copyrights, trademarks, and a certain amount of publishing matters. Principally what I do is either registrations, licenses, transactional work, and also managing disputes up to the point that, well, we try to prevent litigation. We don't want litigation. And sometimes our clients are the IP owners. Sometimes they're the recipients of demand letters. We deal with those. And that's kind of what I do. I like to do publishing agreements late in the day because usually what you see from publishers is really terrible, and if you're feeling feisty at the end of the day, it's a great time to deal with those. So.
Our second question is, what led you to decide to practice IP law?
Same order?
Same order.
Okay. So for me, it really was about client service, frankly. This bleeds a little bit into maybe the next question, but I came to the Triangle in '97 and soon concluded I wanted to work, focus my practice in the biotech and pharmaceutical space, and quickly discovered that in order to really understand what clients were trying to accomplish and to help them meet their objectives, I really needed to understand how intellectual property was used in their business. It's these industries, the patent portfolio is generally the crown jewels of the company, and so to help these companies grow and progress, bring new medicines to market, and deliver shareholder value, really needed to be able to make sure that deals around their technology made sense. So that's kind of the gist of it.
For me, it was much less, I think, designed than perhaps what you said. As I mentioned earlier, I started out just in general litigation. In fact, I neither took an IP class in law school nor have any technical background from my undergraduate days. So, but what I did do and what I've always done is I've always enjoyed complex litigation, especially federal court litigation. I clerked for 2 years, as you heard at the beginning, with federal judges and really have enjoyed practicing in federal court. So I was actually pulled in about 5 years ago on a first patent case I'd worked on, primarily to provide litigation support as someone who is experienced in federal court litigation. Our practice has since grown, and my practice has since grown to where now I am involved regularly in the more technical issues with the technology, dealing with experts, dealing with claim construction positions and things of that nature. So I don't want to say I stumbled into IP law, but to some degree it wasn't what I set out starting to do, but it's something that I've found I've enjoyed very much.
On 82, I came to law school with the idea of going into patent law. I didn't know about the Chakrabarty decision at that point, so timing was good in spite of my efforts. I did consider looking at some other opportunities at the time. I did recall the interview I was at when the two gentlemen, I was reading down to my resume, got to the science part, and both of them simultaneously started laughing at the same time. I thought, gee, this is not going well. And that did cement me in going on into patent law.
Well, I started as a tuba major in the East Carolina Music School. And so that, going from that to biotechnology patent law, I thought it was a logical leap. Actually, I changed majors 4 or 5 times, and eventually when they said you can't enroll unless you finally declare one in the middle of my junior year, I declared biology. And like 95% of the other biology majors, I thought I was going to go to med school. Got pretty much near graduation and decided I didn't want to do that. And some guidance counselor said, well, why don't you think about patent law? I thought, well, maybe law school, environmental law, how can I use science with law? I was really more interested in science than law. I was just looking for an excuse to use science that paid okay. And so this guidance counselor in her infinite wisdom suggested biotechnology patent law. And I didn't have the first idea what it was, but I said, well, that sounds like a good idea. It's better than any idea I'd come up with on my own. So I graduated, I worked for a year as a lab tech at Burroughs Wellcome, which predecessor to GSK. Went to Carolina Law School and went through 3 years, took all of, I think, one IP law class because that was about all they had, and got out and said, okay, well now it's 4 or 5 years since I decided that at this point. Now it's time to go be a patent lawyer. I still had no idea what I was getting myself in for. But I got lucky and it worked out. So that was kind of how, it was more by accident and good fortune than anything.
I was a publisher at an art museum for 14 years, and we used to have disputes with the estates of artists, Picasso and Matisse, and the artists who were big enough to have estates that were, worth something. And so their children and their grandchildren are very litigious. And there was a time when the U.S. simply didn't recognize. U.S. museums thought that if they owned the painting, they owned the copyright. And of course, they were wrong, but they didn't recognize that they were wrong. The Europeans recognized it a lot earlier than the Americans. And so when we'd get demand letters, we just threw them away, and nobody did anything about it. But they became more vociferous, and it was clear we had to do something about it. And as a museum, we were a pro bono client of a large law firm, and the person I dealt with was really the attorney for Paramount and Warner Brothers and didn't know anything about museums. And the museum publishers used to get together at the Art Institute of Chicago once a year and talk about what do we do about these demand letters, and nobody knew. So I thought maybe I should go to law school, and then I'll just come back and I'll be everybody's attorney. So, but I guess I'm getting to the next question. I'll sort of stop there, but it really was an interest in how to respond to the demand letters we used to get from these estates that led me to copyright law, because some of them were justified, and then I began to think some of them are not justified, and it was the not justified ones that were of greatest interest to me.
I should probably ask the next question then. Please describe your career path.
Okay, so some of it was touched on in my bio, but took a couple years after college before going to law school and sowed some wild oats. Went to UVA. From there, I went to White and Case in New York, and really had a perspective of, well, I went into that wanting to do, I actually thought I wanted to do international business deals, which, as it turns out, I now do a lot of. But I found that practice, New York's a great city. I'm from Long Island, and it was, I have family up there. Interesting practice, but concluded that working primarily on large transactions involving financial institutions and the like were not terribly interesting, but some transactions were kind of fun, and the ones I found most interesting were the ones where entrepreneurs were selling their businesses, and typically when I was in New York, I'd be representing the buyers, merchant banks, buying these companies up. Thought, well, the other side of the table looks more fun. At about the same time, we were ready to move from New York to a place with kind of a better balance in terms of quality of life, but also wanted to be in an entrepreneurial market, a place where I could have a good growing practice. And we thought about San Francisco. We thought about Boston. It's kind of cold. The West Coast has really crummy coverage of ACC basketball. So we zeroed in on the triangle. And as I mentioned earlier, sort of when I got here, I quickly concluded that the best way for me to build a practice was to learn a lot about an industry and kind of be able to leverage my experiences from one transaction to the next, particularly in a corporate kind of business lawyer perspective, being able to say, yep, I've got a dozen clients just like you. We know the issues. We can help you achieve your objectives was really kind of how I came to be where I am now.
I started out, went to college at Duke, and either I sowed all my wild oats in college or just didn't have as many as you did to sow, because I went straight on to law school, also at Duke. And when I got out, I really wanted to clerk, so I clerked for 1 year for a federal judge in Raleigh, and then ended up moving to Atlanta, where I'd gone to high school and had family. Primarily moved there actually because my wife entered graduate studies at Emory. But we lived in Atlanta for 8 years. I clerked down there for another year for a district judge in Atlanta in the federal court there, and then joined a small office of a Chicago-based firm, Lord Bissell and Brooke, which had at the time about 25 or 30 lawyers in Atlanta. And I came out of my clerkship knowing that I liked litigation, I liked being in court, but not really having a clue what type of litigation I wanted to do. And in fact, what appealed to me the most were the firms that told me, you don't have to choose right away, we're not going to stick you in our antitrust or our employment or whichever field of litigation. So I joined the branch office of Lord Bissell because that was their approach. And they did a lot of insurance-based work, insurance coverage, and so that was a big part of my practice. I flew all over the country doing depositions in big environmental insurance coverage cases where we represented Lloyd's of London. And then the other part of my practice there was doing a lot of products liability, personal injury, contracting, commercial matters, some antitrust, had a real variety. After about 2.5 years there, I decided I wanted to be at a firm that had more of an Atlanta presence. So I moved to Kilpatrick, and I wanted to work with a larger firm, and where I wasn't just going to court out in Colorado or California. I could do more local work. Also, not so coincidentally, that's when my first child was born, so I didn't want to travel so much. So came to Kilpatrick then in 2001, and again, what appealed to me about Kilpatrick as opposed to some of the other Atlanta firms at the time was that in their litigation group, they also didn't make me choose a particular specialty of law. So I went there, and for the first year or so, did a lot of general litigation, and then have found myself gravitated toward the patent area. Was in Atlanta with Kilpatrick until the summer of 2005 when my wife had the opportunity to teach for a few years at Wake Forest. So moved to Winston-Salem to do that, and really were able to make that work well because we've got an office of about 50 attorneys in Winston-Salem, about 12 of which do patent and about 5 or 6 do trademark, and that of our patent litigation practice, it's Atlanta and Winston basically, and DC as well, but those are the main offices for that. So we've been able to work that relatively seamlessly and actually still have 2 offices and 2 phone numbers and have to go down to Atlanta a good bit because I've kept up a lot of that same practice, but so far it's gone well.
Well, after having my resume laughed at by those fellows, I decided that I needed to go ahead and embrace my inner nerd. I focused on patent practice. I clerked at a DC firm my summer of my second year. That was Shigruma, and where Tim works at as well. And then, not being a big city kind of guy, my wife and I moved to Charlotte, and I worked at a traditional patent boutique firm that was located in Charlotte in 1985. In '88, I moved out to that firm's branch office, and here in Raleigh, worked there. 85 to 88, 90, there was not a lot of biotechnology in North Carolina, at least not patent work, so I got to do whatever came along, and I was very fortunate that I got a foundation in traditional mechanical, what we'd call light electrical, maybe instrumentation type work, and then whatever biotechnology that came along, whether it was a transgenic plant, a recombinant animal, a diagnostic assay, a clone gene. In '97, I left that firm, and with some colleagues, we started our own boutique firm in Raleigh, and I've been there since.
Well, I guess sort of 2 things have driven my career path. One is wanting to stay interested in science and keep up with evolving science, and I'm stimulated by new things, and so patent laws turned out to be a really good choice for that because it's by definition it's always going to involve encountering new stuff. You can only get patents on new things, so you're always working on something that's new and the result of creative people. So that's driven it. And the other thing was quality of life, which I think has led me to be most comfortable in an in-house setting. I want a job where I can go out to the Rockies 2 or 3 times a year and ski, and I can do that in-house. So when I first started out, I was in private practice in 2 relatively small firms in North Carolina. And like Ken, I was looking for something more biotech related, but you kind of had to take what you got, especially when you're first, second, third year associate. So I did a lot of mechanical patent work, a little bit of trademark, a little bit of copyright, but it was good grounding in the fundamentals. And then when I finally got the chance in '96, I guess 3 years out of law school, to go in-house with Siva Geigy in their ag biotech research unit, this was right at the forefront of the transgenic plant revolution, if you want to call it that. They had been the first to market with insect-resistant corn, and then a year later, everybody else came along. So lawsuits just went crazy that year. But at the time, we didn't see that as anything controversial as far as the technology went. We thought, well, this is great. This is going to enable farmers to grow more crops. And the whole genetically engineered food issue really hadn't even risen yet. So I guess that sort of drove me in that direction, just the interest in science. And then subsequent jobs has been the same thing: gene therapy, and now stem cell research. So I guess that's been the biggest driver of my career, is just what's the latest, neatest thing scientifically.
I don't think I've had a career path. It's been more like a ball in a pinball machine. After college, I went to graduate school, but all I ever did was go to the movies. And by the time I finished, I was the reviewer for the college paper and for the local paper and for the Boston Phoenix. So, I didn't show up for graduation. I went straight to Hollywood to be John Ford, and I carried cameras around for a year and then got an assignment from the LA Times, and then for a number of years I wrote for newspapers and magazines about movies, and then from writing, I got into editing, and from editing, I got into publishing. And first, for a while, I was an editor for UCLA, and then freelancing for this museum. And the museum hired me. They said that they were hiring me because I had done edited some books for them, and everybody was still on speaking terms. So had not been their experience in the past. So I went to the museum, and as I told you, there were a lot of copyright issues. And so I saw a review of one of Paul Goldstein's copyright books in Publishers Weekly, and I read it, and I had a question about a footnote, so I called him up. And he said, you know, we have a one-year program for people like you, and which meant people who didn't want to be attorneys. And so I went up to Stanford for 1 year. I took a sabbatical from the museum, but I knew in just a couple of weeks that I was never going back. I was going to go to law school. It was so much, I just loved law school. And I especially liked contracts class. I loved contracts class. So at the end of that year, I had to start applying to, for real. And so then I did go to law school, and I had exactly one interview because nobody wanted a 55-year-old new associate, I think. Anyway, I don't know what the reason was. I had one interview, and they looked at my resume and said, "What did you write for Playboy?" And and I told them, and that was Womble, and Womble hired me, and that's the end of my career. I mean, I don't think they would have to lead me out under they'd have to carry me out, because I don't think I would ever leave there.
Could you describe a typical day at work?
So for me, a typical day, I'll get to the office around 8:30. I'll probably be there till about 7. And the day will be divided up. Often there will be a client meeting in there for say an hour. Most of the rest of the time is split. A lot of time on the phone, either counseling clients about transactions, or on conference calls with opposing counsel negotiating transactions, and then some time spent working on documents, revising the contracts that Mitch and I love so, as well as working with junior associates or other associates in our firm, advising them on matters that I've delegated to them, so they'll check in, and probably a couple nights a week I'll spend some time either in some kind of networking function or entertaining clients, taking them to a hockey game, that sort of thing. And then board meetings with clients are sprinkled in, probably, once every other week, something like that.
I kind of almost have to set 2 typical days, because of the nature of what I do. I'll give you an office day, but then also want to mention something about when I'm not in the office and what type of day I would have in those occasions. A typical day for me is I typically get in around 8 o'clock. I typically work. I try to leave around 6, which most of the time I'm able to accomplish, just so I can be home for dinner with my family. And when I'm in the office for a whole day, I usually will have thrown in there a couple of conference calls, either with clients or with opposing counsel on cases that I'm working on. Strategy type calls with clients, or conference on discovery matters type of things with opposing counsel. I typically will be managing or supervising more junior lawyers' work on matters such as discovery, briefs, things of that nature, and so we'll typically talk with them or review their work product and provide guidance to them either by email or over the phone or in person. And typically we'll have maybe one or two things that I'm working on, documents that I'm working on myself, a brief or a letter, for example. So that's a typical office day for me. And then I also want to mention about, because since I'm a litigator, I do a lot of, things such as depositions, hearings, trials. I do mention a little bit about that. When I'm in the office, I'm able to stick to a relatively regular schedule most of the time. But obviously, as I have things come up like depositions or hearings or trials, that obviously changes. And so a lot of times I'll be out of town for those events. Even when I'm in town, though, those typically involve a lot longer hours, a lot more focused preparation, where that's all I'm doing for the day is either getting ready to go to a hearing or being in court at a hearing or at a deposition all day. And so you'll have these days sprinkled in there where you're just singularly focused on one thing, and typically would have to work much longer hours, both getting ready for and actually doing that, than you would a normal office day.
My typical day would go 8:30 to 6-ish. And patent practice is very bar date and statutory bar date driven. So we have a docketing department that'll lay out my due dates. And I'll typically come in with 3 or 4 things in mind that I want to work on, hopefully comfortably in advance of the deadlines, maybe not always so. And then I'll get an email from a client or a phone call from a client, and it will be something that I'll either handle then or put onto the docket or might consider handling then, and go back to the other things that I was working on, either things that I'm doing or things that I'm supervising. And then I'll get another call and another email, and make a decision about whether I'm going to deal with that or stick with my 3 or 4 things that I had hoped to do. And that'll pretty much progress on for the day. And by the end of the day, I'll look back and see how many of the 3 to 4 things I had hoped to do I got done, and refigure out starting the next day what I'm going to do. Hopefully I got at least one of them done.
Well, I'm usually in the office by around 9 or so, and I typically leave around 6:30 or 7. I tend to get a little bit more work done, it seems, in the afternoon after people have started to drift off, because a lot of my day is I'd like to think of as just practicing law by the seat of my pants, because I'm right in the middle of a bunch of labs. There's a few offices, and then there's labs everywhere. So you get scientists coming by your office all the time. You sit down and eat lunch with them in the employee cafeteria, and they're always asking you this or that, or you get a call or an email from somebody in management, and they don't want you to say, well, I need to do some research on that, I'll get back to you in 2 or 3 weeks. No, they want an answer by that afternoon. So you have to kind of just go with your gut sometimes, make the most informed decision you can, and hopefully you're so immersed in what the issues are from having the very focused practice that an in-house job brings, that you are able to do that. You do have things you try to plan for, drafting a contract or working, meeting with outside counsel to go over a particular patent application, that sort of thing. But I would say at least half my day, I'd almost need to block out about 4 hours at least for just whatever comes up that day. And you don't know what it's going to be on any given day. You sort of have to plan for the unplanned in an in-house job.
During the time that I was working at the museum, I'd do that during the day, and then I would ghostwrite books at night. And one of the first books that I ghostwrote was a time management book. I mean, it was really how to use a day timer, that's all it was. And it was putatively written by someone who had plenty of time to think about it in prison. And so for whatever reason, it's certainly not my favorite book, but for whatever reason, I'm very aware of time. The first thing I do when I get into the office at 8:30, because I'm an associate, not a partner, is go through all my time entries for the day before. And while I've been keeping the minutes, I kind of add them up and figure out where I stand in terms of the goals that we have to meet each month at the end of the year. And so really, the first thing I do is think about time, and I hand those entries to my secretary. On Mondays, like today, it takes as much as an hour to go through the previous week's list of projects, get rid of the ones that were done, completed, add the ones that have been coming in since then, and just get a good sense of what's there. My desk is really littered with paper, and that can be very oppressive, when you see these mountains of paper and you don't know what is that. Is there something I'm supposed to be doing? Is there some promise that I made to somebody? So, managing your time it takes a little while, but it's such a blessing. So I start out my day with just time checks. But from that point onward, I generally have a good idea of what my priorities are, what are the priorities of the people who've given me work, because associates get work from partners and you have to be thinking about their priorities. And then always there are emails, there are phone calls, there are people who think that you really should be working on something else, and you have to determine, you just have to get to the point where you can say, I'm the one who knows what's on my desk, and I'm just going to have to set these priorities myself. And you do your best to just do that, watch eBay, and just do what needs to be done by the end of the day. But sometimes there are days when I go, I can't do this all, or nights when I find myself writing contracts for things that don't even exist, and I can, picture all the terms, and it's not about something I'm even working on. And because it's just there all the time. But then there are other days when it's controllable. I spoke with someone yesterday who said in his 20 years of practice, there have been 2 or 3 times when the amount of work was just perfect, and that never lasted longer than 18 minutes. So, but that's really what your day's going to be like. It's either your day or it's somebody else's day, and you just kind of have to decide.
In the interest of time, I'm going to ask one final question and then open it up to you guys to hopefully ask what he wrote about in Playboy. So the last question will be, what is your best piece of advice for someone in law school who wants to work in a job similar to yours?
So I would say think about some sort of industry focus. Think about where what interests you, and leverage that. Because if you're passionate about it, you're gonna enjoy it more. You're gonna be much better at it. So I would say think about something that is of personal interest, and drill down on that. If there's money in it, that's good too.
I would say if you wanted to do a job like mine and be a litigator, I would say, regardless of your focus on IP or any other area, I would say learn to be the best litigator you can be. I found that clerking for a federal judge, for 2 federal judges, was the best experience I could ever have. Of course, starting salaries at big law firms weren't what they were then, so I didn't have as big of a decision as to face in terms of salary gap as perhaps many of you do. But I nonetheless would recommend at least 1 year clerking for any judge, federal or state. That's going to be the best single learning experience you can have, and would put you far, far ahead of people who don't do that if your goal is to be a litigator. And I would also say that if many of you end up working for big firms and you work on, for example, a big patent litigation or any other large litigation, don't let that be your only focus, because you're not going to be able to develop into a good litigator if all you do is work on big cases and review documents and do research your first few years. Look out for opportunities. There are even the biggest firm will have opportunities for smaller cases or pro bono matters where you can get into court yourself, because that's really what it's going to take to let you advance rather than always doing the work for someone else.
I'm going to echo that. I'd say pay attention to building your skill sets, and the skills you'll need 10 years out to do good client counseling are not necessarily identical with what you're learning when you're focusing on making billable hours. I mean, certainly a lot of what you do while you're billing at the early stages of your career does translate into building skills, but not all of it, and looking for chances, well, as Bill said, to get to know a client or an industry, or Steve said, getting to, I guess, doing a different type of litigation or going out and speaking publicly or writing. These are the kinds of things that build your skills so that down the road you can be more effective at client counseling.
I guess my advice can be kind of narrow, just if nothing else, just because it was sort of personal to me. I would recommend, if you're going to get into a really technology-driven area of law like patent law, don't discount the idea of getting another graduate degree or at least an MBA if you're going to get into a pseudo-management position at say, a biotech company. I felt like I got really lucky to have gotten my job in-house with Siva Geigy with only a bachelor's degree in science in biology. I more recently went back and got a master's in the evening at Johns Hopkins, which I was able to finish online after I moved back to North Carolina. But the high-tech patent world, especially in the life sciences, is becoming so crowded with people who have graduate degrees that then went to law school. I think the opportunities for someone without a graduate degree in some areas are becoming much more limited. So might be a little late for some people, but I think it's something to consider if it's at all possible.
I would echo the first words said, and that is to pursue your own interests. When you are being interviewed for a job, I mean, the firm is considering you. I mean, it's not like every applicant is just a cookie-cutter version, and so the interests that you have are going to be very important, and they may not be even your academic interests, but any interests. And those will stay with you and can become the source. They can make you unique, and a practice can be built around the things that you alone are interested in and you alone can do. Another piece of advice would be to learn to listen very carefully, listen to precisely the things people say. If you anticipate what they're going to say, don't interrupt them and put the words into their mouths, but listen very carefully to what they say, and that's a skill that you will need. And finally, when you go on an interview and it involves a meal, don't order anything you have to eat with your hands, because that is going to be a disaster. Yeah.
Does anyone have any questions for the panel? Yes.
You have a hard science background and you're trying to determine whether you want to go to a big firm when you graduate and work corporate or IP, either litigation or prosecution, but you don't think you want to stay at a big firm for more than like 3 or 4 years because you don't think that would be a good lifestyle for you. What do you think how do the exit options compare for somebody that does corporate at a big firm versus somebody that does IP, litigation, or prosecution, like in terms of abundance and compensation?
Well, I can start. The exit options, you said?
Yeah, like
where you go from there?
Yeah.
Yeah. I mean, there are a variety of, well, I'm assuming you're talking exit option going in-house. I mean, there are obviously a lot of other opportunities, both with smaller firms and a lot of other organizations. I think, from my perspective, if you do pure litigation at a firm and you're seeking a litigation, for example, an in-house litigation opportunity, those would be fewer and farther between than if you were in corporate law. I think or patent law, for example. There are a lot of in-house patent lawyers, a lot of in-house corporate lawyers. Now, having said that, I know plenty of litigators who went on to get in-house jobs and are now in a more of a transactional role. So it certainly doesn't exclude you. Whatever focus you take wouldn't necessarily exclude you from having an in-house position, and certainly would exclude you from working at a smaller firm as opposed to a big firm.
When you say,
if you want to weigh in on that.
when you say patent lawyers, do you mean specifically prosecution?
Well, it means people that have a registration number.
Okay.
Yeah.
Speaking from somebody who's been in-house most of my career, it's almost never will a company hire somebody straight out of law school that doesn't have some law firm experience. BD almost won't even consider anybody unless you got at least 5 years of law firm experience. when I was with Novartis in its various incarnations. The only people that came straight out of law school were people that had gone, there had been scientists and they were IP liaisons, they became patent agents at some point, went to law school at night at Central or someplace had an evening program. And then when they got out, they already had all these years with the company. But just to come right out of law school and go in-house is pretty well, it's not unheard of, but it's rare. So most places, getting that 4 or 5 years at some big DC firm or whatever is pretty typical. And all the in-house lawyers that would be hiring people like that, they've all done it themselves. So they see that as kind of a natural path to go through.
I would, just one last thing to echo on that, I would, if your goal is to go to a big firm and work, I would choose your specialty area based on what you really like to do. And obviously judged in the sense of going through a summer program or something like that, what you enjoyed and who you enjoyed working with. I wouldn't worry too much about down the road, how will this fit in with me getting an in-house job or some other job, among other reasons, because I had that same mindset when I joined a big firm 8 years ago, that I'd be there 3 or 4 years and move on, and I'm still there. So you never know what you'll actually enjoy. And if you pick something you do enjoy, you're more likely to enjoy it while you're there, and be, leaving because you're miserable is a lot worse than leaving because you have another opportunity. So I would say pick what you like.
Any other questions?
Can you each talk a little bit more about the client counseling aspects of your job, like how you interact with your clients and the type of advice that you need to give them in practicing? And I know for Tim it's going to be a little different for you because you're surrounded by your client.
Sure, and mine may actually have some similarities with Tim in that for many of my clients, I serve effectively as their general counsel, not patent counsel, but there are all kinds of issues that crop up, and one of the things that makes it a lot of fun is particularly for the earlier stage companies or the companies that I work particularly closely with. Yes, they ask questions about the law or about this contract. What does this contract mean? Or do you think we can negotiate to get to a certain particular end result? But in other cases, it's we need to find we need to find somebody who can help us solve this sort of problem. Or do you think, what do you think about this valuation? Is this reasonable? Are these business terms, do they make sense? And I can, based on sort of having worked on a lot of similar deals, can say, well, this part's okay, but I think we can do better in certain areas. Or have you thought about, how all of this will get affected if we want to sell the company or sell off a division? And so it's I guess what's fun for me is it's very broad range of things. It can be about people, it can be about technology, it can be about finance, and it can be commercial terms.
For me, it's probably a little different just because I tend to deal with clients the vast majority of the time in areas where they've either been subjected to a lawsuit or are considering bringing one themselves. And so there's definitely, in addition to the normal counseling you'd give a client, there's that aspect of what should we do in this specific suit or this specific situation. What serves our interests in going forward? How hard should we fight it? How long should we fight it? What resolution should we try to achieve? And so those are the type of counseling that I'm typically involved in. And how it goes will depend on the client. Just as one example, we've done some patent litigation work for Motorola, which is a very large company, has its own patent litigation in-house counsel who we deal with, who was at big firms, and so obviously is very sophisticated about these things. And so you're kind of counseling on one level there versus I've represented some smaller companies and especially foreign companies who have no in-house lawyers at all. And so in that instance, you're having to explain to business people who don't have the background of being in the United States for very long and knowing our litigation system. So it can span that whole spectrum, and obviously the amount of information you need to give the client to enable him or her to make the best decision that's in their interest or their business interest will vary widely based on the situation you're in. But it all generally relates to how do I handle this dispute and what's my best interest for either fighting it or getting out of it.
An odd thing about patents is they often have to be filed very early. So You meet with the scientists, you meet with the business development folks, you come up with a plan and theory and vision of where things are going, and you file it, and then time marches on, and new innovations come along, focus is gained, and then you have to, one, remember, and two, revisit the prior strategy and see if it fits, and potentially look at what your competitors are doing, and see if you have problems there. A patent application on an important technology in biotechnology or chemistry can take 10 years to prosecute, U.S. and worldwide. So it's very strategic, applying the case law in the patent field to the technology at hand, and I enjoy that strategy part of the technology a lot, of the practice a lot.
Part of it, I can just reiterate what Ken said, that the strategic planning is a really big part of what I do. Other parts is education. You got all these people asking questions all the time, and it just makes my life easier if my clients, i.e. the researchers, know something about IP and why we care about it. Just getting them to care is a big part of it. The other big part is just facilitating things. They're scientists. They came from academia. They're going to do what they want, with or without the lawyers. They're going to collaborate with their old, buddy that was a postdoc with them, whether I put an agreement in place or not. So it's in the company's best interest if I, rather than, in an impediment that they're just going to go off and do what they want without involving. They want to involve me. They know why it's important, and just facilitate, an interaction that they want to have with someone. And just be the go-to lawyer that helps them rather than just forms a bottleneck.
Because I'm a transactional attorney, I'm dealing with people who have business interests, and what they really are looking for very often is not an explanation of what the law is, but they just want to know, how do I make the best business decision, and what do I need to know about the law, or what do I need to know about what's going to happen in the context of the business. I also find that when I write to clients explaining, we just got an office action from the PTO, or we just, there's this opposition going on, or we've just received a demand letter, something like that. You can dash off an email, but it's really better to spend the time to tell the client everything the client needs to know in order to make his or her own decision. It's going to be the client's decision. And if it takes a little longer to polish an email and get it exactly right, that's time that will be saved in the end when you don't have to have an endless email exchange asking for clarification, so on and so forth. And it also, of course, goes in the file and shows that you did it, but that's, that you informed them, but that's a different point. I also find that it's easy to become really friendly with the clients, and you always want to be cordial, but remember, these are not actually your best buddies. And so you have to maintain, exactly the right kind of friendly but professional relationship. Another thing is that very often you're dependent on clients for information, or you just need to get something out of them printed on their letterhead or something like that. And you do have to hound them and remind them, because it's not all, what is your priority is not always their priority. But in the end, it works out really well. I love working with clients.
Any other questions? Yeah.
Can you guys say anything about the state of the IP, I guess particularly patent, if IP is too broad, market in North Carolina at the moment, especially in Raleigh? Like, is there a lot of work going around? Is it a growing field here?
It's growing. I don't know that's the hottest location in the country. It's kind of like the job market in this area. I'm sorry, kind of like the housing market in this area as opposed to other areas of the country. It's been a moderate, rational growth over the past 10, 20 years, and I see that as continuing.
Yeah, I'd concur with that. That's, been the experience of our firm. A few years ago, we didn't have a patent practice. We've brought one in, and it's been growing at a steady clip. And I think that's our perception of what else is, what's going on in the rest of the market.
Any other questions? Go ahead.
In the field of patent litigation, do most attorneys do whichever side their client needs, or are there some attorneys that tend to stick more on the plaintiffs or the infringement defense side?
There certainly are, firms like the NIRO firm in Chicago, which are known as plaintiffs patent firms, and I think most, they're obviously a boutique. Most large firms that have a patent practice will do both, and I think it is good to do both. I've always came up litigation from a defense perspective, but I've actually really enjoyed doing a lot of the plaintiff's patent cases that I've done. So a lot of big firms will tend to have, repeat clients, and so those clients, particularly the ones in the technology areas or with a strong R&D component, will have a lot of their own patents and may well want to enforce those against their competitors. So if it's a big firm, I would say probably both. Boutiques, you'd really have to go to a specialized boutique. For example, if you just want to do plaintiff's work, there are a few of those, but by and large, most firms do both.
Yeah, I'm not a litigator, so I'm observing this from the sidelines, but the one area I do see some compartmentalization, and it's not due to formal conflicts, but it's just picking sides of the businesses, is in pharmaceutical patents, whether you're representing the patentees or the generic drug companies. And there I do see firms picking sides.
Yeah.
Some of the big pharma companies will refuse to use a firm that also represents generics.
Is that due to conflict rules, or is that just a culture thing?
More of a matter of principle.
Business conflict, isn't it?
Yeah, they just hate generics so bad, they don't want to use lawyers that will
And
cozy up to them.
That's generally true in many industries. If we get one client in a particular industry, we know we're not getting any others, even if there's no formal conflict that would preclude us from doing that work. So, but I think the pharma industry is probably one of the most fierce in that regard.
Well, I believe we've actually run out of time. Many of you have to go to class. If you have any lingering questions, feel free to ask the panelists, but help me thank them.
Thank you, and don't forget your dessert.
Yeah.